I say I take my bag of Prince of Wales tea and I go to the coastline and I drop it in a few times and I create the weakest, largest cup of tea in the history of the world from the fact that I have freely committed my labor to something owned by no one else and have brought about something that previously did not exist. Do I have a property claim to the Atlantic Ocean? Well, clearly, no. Locke does have certain reservations about property rights, which some of the founders, particularly Madison, found unacceptable. And as far as the founders go, Madison and Jefferson were not of one mind on property. Jefferson, for example, opposed the notion, the institution of primogeniture, and was very, very skeptical about having the right to pass one's property on to succeeding generations, arguing that any time that exists in the world, the natural consequence is an aristocracy whose fraction of the available wealth increases steadily as the balance of society gets poorer. You see, he had these views. Madison, who's usually at one with Jefferson on so many things, was not with Jefferson on that. In fact, I think to put the ball in play, I'd like to read you a passage from Madison. He wrote a long article titled Property. Very few people, I think, read Madison on property. They keep reading that Bill of Rights, which he didn't want to write, which he did because the Anti-Federalists insisted on it. And Jefferson wanted it, etc. So he did it. There was a lot of opposition to the very notion of it. Why? Because to delineate the rights is to limit them. Secondly, to delineate the rights is to suggest that their source is in the document. The rights are not derived in virtue of the fact that a constitution has been written. Unless you had these rights, the constitution you authorized would have no standing at all. So the rights in question inhere in the very creatures who agree to be governed by a document of their own authorship. Now, this is very different from the British experience. And property is very different from the British experience. I tell you, one of the things that agitated Locke. The Glorious Revolution is 1688, the so-called, it wasn't entirely bloodless, by the way, the revolution that put an end to James II and the possibility of the restoration of Catholicism in England. With the end of that monarchy, a monarchy whose possessory rights in principle are limitless, but who can take the possessions that royalty claims and dole them out in dukedoms and principalships, etc., rewards, can create entails. What happens to all those properties which followed along the line of the Stuarts now that they're gone? So Locke does want to get back to the drawing board and make clear that there are certain pre-governmental rights. They antecede any government. They, to some extent, are not God-given. In fact, he's much more inclined to give the monarchy the path to heaven. But they inhere, as a gift of reason, we understand that persons have a right to what they've worked to bring about. It's only reasonable. Now look, Locke was a first-rate physician, and he was a good philosopher. He's a highly celebrated philosopher. We long ago gave up the proposition that the way you account for something is by saying, well, just think about it, it's only reasonable. That means that anyone who takes exception to your position must be a lunatic. Yes, it is reasonable to suggest that when a person has freely mixed their labor, extended themselves by virtue of their labor to bring something about, they have some sort of a claim on what was brought about. But it's also reasonable to say, well, that depends on what they're going to do with it. And Locke does set limits on what one might do with it. One of the limits set on it is you read chapter 5 in a certain way, and he's saying you take just so much as makes sense, and you leave the rest for others, the so-called benevolence condition in chapter 5. Now, what hale and hearty American conservative is going to put up with that notion? I take just as much as I need and benevolently leave the rest. You know how Hobbes treated benevolence? He referred to it as a niceness. What's the Hobbesian fundamental right? The fundamental right is that I defend my life. And that means that in principle, each of us is at war with the other. Unless this thing spill over into the street, we are prepared to invest our individual powers in a great power that will secure that most basic of rights, which is our survival. We invested in something Hobbes called Leviathan. Is that the world that our founders thought we should aspire to, or were living in, or were governed by? This is where the founders quite cleverly said, look, yes, we've read the philosophers. Jefferson was asked about where these dazzling words in the Declaration came from. Oh, he said, I don't know. Aristotle, Locke, these verities have been in place since human beings began critically reflecting on their most basic principles, began critically assessing the things that they otherwise took as true, recognizing that truth claims appear before a jury, and the jury is the jury of reason and the jury of historical experience. So I want to say, as sort of part A of my quite attenuated thesis, that although the founders read and admired Locke, the best understanding of property rights within the context of the founding is not chapter 5 of Locke's second treatise. It's something worked out by the founders. Now, there is this passage in Madison's essay on property, which I think makes the point quite clearly. This is a quote. He published this in the National Gazette in March of 1792. If there be a government, then, which prides itself on maintaining the inviolability of property, which provides that none shall be taken directly, even for public use, without indemnification to the owner. That all sounds good. So grant that government, and of that government, yet directly violates the property which individuals have in their opinions, their religion, their persons, their faculties. Nay, more, which indirectly violates their property in their actual possessions, in the labor that acquires their daily subsistence, and in the hallowed remnant of time which ought to relieve their fatigues and soothes their cares, the interference will have been anticipated such that that government is not a pattern for the United States. And here, what Madison has accepted, what he has, as the expression goes, bought into, is the commodity theory of rights. That is to say, all of the rights, properly understood, are property rights. The freedom to speak, to espouse the terms of a given religion, this is part of what I own. And by way of the Scottish Enlightenment, and particularly Francis Hutcheson, who had more to do with installing benevolence considerations into our founders' thinking than perhaps anyone else. But owing, I think, chiefly to Francis Hutcheson, we were able to make a distinction between alienable rights and rights that cannot be alienated. Now look, you're all politically interested, savvy, educated people. And if I picked on young ones, which is what God intends me to do, and I were to ask one of you two fellows, what could possibly make a right inalienable? Which rights are inalienable? And you're not going to parrot back life, liberty, and the pursuit. You say, what's so inalienable about those? Now, what did Hutcheson argue? Hutcheson argued that a right cannot be alienated to the extent that the person himself cannot alienate himself from it. And what does he offer as exemplum number one? The claims of conscience. You can't give your conscience away. You might pretend to do it, but you know you can't do it. You know that you can't take something to be definitely positive and declare it to be negative if the price is right. You may do that with a felonious heart, but you still hold on to the judgment that X is right. So conscience itself, that is to say, moral sensibility, is something we cannot alienate from our very nature. You don't need a document that guarantees freedom of conscience, because conscience by its very nature is free, but it is not free as a commodity that can be given away. Now, over and against that, there are commodity theories of rights. You can package them, you can give up 3 of them to get 2 that you like more, et cetera, et cetera. And to some extent, Madison was in the commodity end of things, particularly when he says all these rights guaranteed by the Bill of Rights should be understood as one's property. Freedom of speech is something one owns. Freedom of religion is something one owns. You don't get this out of Locke. I come neither to praise nor to bury Locke. John Locke is a great figure. Did the founders read Locke? The founders read everyone. When John Adams applied for admission to Harvard, the admissions interview was conducted in Latin. This was a very clever generation. We don't refer to this age as the Enlightenment without reason. When the question was raised yesterday, how important is a university education for one who would be president? This, of course, raises the question, what counts as a university education? Now, since I know of no place where I've taught in the States, I've taught at Georgetown, Princeton, Columbia, and Amherst. They all claim to be very special places. I wouldn't regard any of them, and Princeton, as hosting anything I would call higher education, because it doesn't get around to the question of what it is in an education that makes it higher. An education is higher when it addresses things that by their very nature are higher. And that's not an open curriculum where you can major in either electrical engineering or poetry, et cetera, et cetera. It's very pricey. We're all very, very clever. Hang around, we'll give you a degree, and it'll be worth a lot because it's an Ivy League degree. These are credentialing institutions. Am I waving an Oxford? Well, Oxford, you know, we have an expression there that when it comes to higher education, the first 900 years are the toughest. Well, we still have greats. 33-hour examination conducted over 6 days, in which the questions are raised in Latin and must be answered in Greek, etc. We still do things like that. It's very difficult. I thank God daily that I'm not sitting that examination. But I say the founding generation was educated whether it went to university colleges or not. When Edmund Burke gives his speech for conciliation with the colonies in 1775, he wants to alert his fellow parliamentarians to something they may have overlooked. He says, I am informed by London booksellers that they sell more books in the colonies than in all of London, and especially on the subject of law. These people know what they are about. Now, that's the kind of education. Of course, a president should have that. We must have that because we're a self-governing people. When John Adams wrote to Jefferson and said of the U.S. Constitution, "This will work only for a moral people. It will work for no other." Now, what was he getting at? Was he moralizing? Was he finger-wagging? Was he a scold? No. This was the first time in the history of the world where a nation was created on a date certain by people whose names we know. And the whole point of this was to announce to the world that the ultimate source of sovereignty is the person. That, in fact, this is a self-governing nation. Well, if it's a self-governing nation, then the government is going to reflect the character of this self-governing people. So when John Adams says that this Constitution will work for an essentially moral people and for no other, that's what he's getting at. You could have an extremely virtuous prince or king who required you to do coercively what a virtuous person would do voluntarily. And you might get a very commendable population, very well behaved, not as robots, but highly disciplined, honorable in their dealings, and understanding that you're either honorable in your dealings or else. But suppose you are the source of the law. You determine what will bind you. And suppose you're just the wrong sort. Then, in fact, your laws will be the wrong sort. And to the extent that character is shaped by civics, which Aristotle taught a long time ago, characters will become stultified, and there'll be no full realization of our humanity. And that's why Adams said, if we're not a moral people, this is just 17 pages of gibberish, do you see? Another word on Locke and property. The first major jurisdictional dispute settled by a U.S. Supreme Court was Chisholm versus Georgia, which was decided by the court in 1793. It's an interesting case, by the way, and the final settlement, for those of you who think there's something about law today that requires a whip and a chair, the final settlement on Chisholm was 48 years later. I mean, there were all sorts of side litigations and so forth. Chisholm was representing a family that had made contributions to the revolutionary cause to the then colony of Georgia, expecting that just in case the project worked, there would be a return on their investment and so forth. Well, the project did work, and Georgia was a state, and we were ready to roll, and Georgia wasn't making payment. Chisholm, representing the affected family, brought an action in federal court, and it worked its way to the Supreme Court. Georgia took the rather arch position that the state of Georgia could not be sued in a federal court because Georgia had something called state sovereignty. Now, I know I'm at CPAC, and almost all of my leanings are quite conservative. And we can jump up and down and plead the case for states' rights as soon as I'm finished. But let me tell you what the majority opinion in Chisholm concluded. The authoritative, in those days, every justice, there were 6 of them, every justice had to write a separate opinion. And the one that came down as the authoritative, most discerning of the opinions written was the one written by James Wilson. James Wilson may have had the best legal mind of that group of 55 in the hot room in Philadelphia with the blinds drawn and, creating a nation. Wilson was an extraordinary fellow. Had to beat a path south to avoid debtor's prison later in life. He made some bad investments. But he had a steel trap mind, very much a product of the Scottish Enlightenment himself. He had degrees from Aberdeen and Glasgow. He looks at George's defense in this action, and he begins the way we always want Oxford students to begin, by attempting to define terms. He can't find the word sovereign in the U.S. Constitution, so he's got a problem. Georgia is claiming to be something on constitutional grounds, and what Georgia is claiming to be appears nowhere in the Constitution of the United States. So the question is, how are we to understand Georgia's self-ascription of sovereignty? And then he does a delightful sort of analysis. And he says, if you want to know the core principles on which this analysis depends, I recommend that you read Thomas Reid's Inquiry into the Human Mind. Reid was one of the leading figures in the Scottish Enlightenment. I've said to classes, show me a Supreme Court that's citing Reid's Inquiry into the Human Mind, and I want to live there. Today I think they cite, Newsweek or something. But, and of course they all went to Harvard, and I am powerfully impressed. So Wilson says, well, let's do it this way. You think someone living in Massachusetts can bring an action against somebody living in Georgia? You think somebody living in Massachusetts can bring an action against 2 people living in Georgia? How about bringing an action against everybody living in Georgia? Is Georgia's claim that just in case no one lived there, there's still a sovereign entity that is Georgia? Because if that's true, and this is a powerful quote, if that is true, we cannot have a nation. Do you see, if each state can claim a sovereignty over the Constitution itself, that is, it cannot be held to the terms of the Constitution, and the Constitution is what constitutes the nation, then either Georgia is right and we cannot have a nation, or Georgia is wrong. Here's the correct answer. Georgia is wrong. Nonetheless, the concept of sovereignty has not been exhausted, so Wilson goes further. He says what Georgia must be claiming is the status we generally accord to a lawgiver, a sovereign. And he reaches a conclusion that probably should bring a tear to your eye. He said, we have such an entity. Sovereignty, you see, is in the man. Sovereignty is in the person. The person is the source of all powers any sovereign might claim for himself. And when you see the pundits and some of our political leaders choking when they hear the question, well, excuse me, and how would you define a conservative? What does conservatism mean to you? Well, it means smaller government and lower. And you sit there saying, my God, what would Wilson say? There's a very direct answer to the question what it means to be a conservative. It's to recognize that the ultimate source of sovereignty is the person. That everything that is done in defiance of that proposition is incompatible with core conservative principles. I have a minute, and you must have some questions. So please. Yes, sir.
Would it be correct to say that the sovereignty, which you describe as a form of property, this is not my field. By the way, I'm an electrical engineer, so thank you for that.
Yeah.
Would you say that that sovereignty is licensed to the government? I am a licensor, is the licensee, a license can be modified or revoked?
The reason I hesitate is because that establishes an in-principle distinction between us and the government. We are the government. What we do is, you might say, is license some representatives to make sure that the laws covered by the Constitution are faithfully executed. And we hold them to a very high standard. I don't know why the probability of re-election is so high. I think the founders expected that these seats would be vacated quite regularly, that they would not be career politicians. Yes?
Barack Obama most certainly got the question on American exceptionalism wrong. I'm hoping you can get it right for us.
Well, I think once you've established a form of government in which sovereignty inheres in the person, and that there is no meaningful distinction to be made between the consent of the people and the laws under which they agree to live, that this certainly is historically exceptional. You didn't get this in Greek democracy, in case you're wondering, by the way. The principle in Rome was of the shut up, I explained, school of rhetoric. I don't think Barack Obama knows anything about the Constitution. I know he supposedly did something at Chicago, but Chicago has a very good law school. He couldn't possibly have taught constitutional law at Chicago. He must have been doing something else. You realize these people always have some sort of shady back. I mean, you're supposed to be looking further, you know. Here I am, 79 years old, fat and breathless. I teach philosophy at Oxford. I give the core lectures on Kant's critique of pure reason. Any other question? You know, but suppose there's something like, well, I don't actually teach Kant's critique, but I sometimes use his name. I once wrote a paper with Kant's name in it. I think he taught at Königsberg. They're always hiding behind some collection of titles. I don't think this president or the one that preceded him or the one that preceded him, why did Ronald Reagan not need the University of Chicago Law School? Because he understood that sovereignty inheres in the person. If you get that much, you know, the Constitution is not a terribly thick document. You don't need 72 volumes to cover the statutes of New Jersey. Please. We claim that a Congress is a do-nothing Congress because it didn't pass a lot of laws. Is that what you want? More of them? Do you see? Last night, there were some statements made about higher education in America focusing on the use of condoms. Well, if you've met as many graduates of American colleges and universities as I have, I'm not sure that teaching them the use of the condom is that bad an idea.